I'm going to admit.
Okay.
So far, so good. Good evening and welcome to one and all. It's a pleasure to welcome everyone to this special evening, and it's a personal pleasure to be able to welcome our outstanding panelists and moderator. Really, three wonderful and just top flight educators in our community. We're so privileged to have you with us this evening. I just wanted to begin with a word of thanks to Hanno for envisioning and sponsoring this annual lecture series. We took a little break during COVID, and we're so happy to be back thinking about and talking about the intersection between Jewish ethics and Western ethics, which was Hanno's vision for this annual lecture series, one of the critical junctures and one of the rare opportunities to think about this intersection in our public discourse. So thank you to Hanno for your vision and your generosity. And let me thank too ORA, not to be confused with our moderator, but ORA, the Organization for the Resolution of Agunot, the organization, for co-sponsoring tonight's event. And let me just remind everyone that almost exactly 1 week from tonight is the Jewish Center annual dinner. We'd love to have you with us as we celebrate the Jewish Center and honor the members of our COVID vaccine task force and the minion makers over this past year. If you've not already registered, please remember to do so. In a moment, I'm going to hand things over to our expert moderator, Ora Weinbach, not to be confused with ORA, the Organization for the Resolution of Agunot. But before I do, I just wanted to say one quick word. You know, the Torah tells us, Zos HaTorah Adam Ki Amus Ba'ohel. We learn about the consequences of death in the beginning of the Parsha on a kind of conceptual or theoretical level. And then we read the continuation of the Parsha and it happens. And we learn about the passing of Miriam, and we learn about the passing of Aaron. And we see in the narrative the consequences of what it means, Adam Ki Amus Ba'ohel. Sometimes in thinking about issues as they pertain to ethics, we kind of remain on a 30,000-foot level, and we think about concepts and ideas and values and theory, and those conversations are very important to have, and they're very valuable. But sometimes we're hesitant to bring them back down to their practical application, to think about what they mean in the lived experience of our community and the lived experience of Jewish life. And so tonight we're so pleased and so excited to be able to think not only about theory but also about practice. The issue and the challenges surrounding Agunot are not academic. They are very real, and they affect the lives of real people every single day. Part of our sacred obligation as a community is to think about how we can help address those issues. So this is not just the realm of theory, but also the realm of practice, and it's a great testament to our community that there's a willingness to engage these challenges as they may be. So at this time, it is my pleasure and honor to turn things over to our expert moderator, who will tell you a little bit more about our speakers and about the format of the evening. Please join me in welcoming Ora Weinbach.
Thank you so much, Rabbi Levine. And also, thank you. Welcome everyone to the Mott lecture on Jewish ethics. This evening, as Rabbi Levine mentioned, we're going to be tackling a really challenging topic. A get is a Jewish divorce document, and an Agunah is a woman who has not yet received a get from her husband. The word Agunah literally means chained and references the fact that this woman is unable to move on from that marriage and remarry according to halacha. In rabbinic literature, as we will hear more about, Agunot were often the result of men disappearing at sea or never returning home from war. Nowadays, however, most cases of Agunah are the result of conscious get refusal. In these situations, a get is intentionally withheld by a husband or utilized as leverage in divorce proceedings. This overview that I just gave is, of course, an oversimplification, and we're going to get into more nuance over the next hour. But as Rabbi Levine just mentioned, before we jump into to the details or the theory, it's important to acknowledge that get refusal and agunot are an extremely painful and in many cases very personal topic. There may be some people on the Zoom who are or were agunot. There most certainly are people on this call who went through the experience of receiving a get, myself being one of them. And for many of us, the process was not pleasant, even when it worked out the right way. Not all of the people who get hurt by get complications are women. Husbands and other family members can also be impacted by get refusal. For anyone watching who finds this topic emotionally challenging or upsetting, just know that you are not alone. And please feel free to reach out to myself or any of the Jewish Center clergy to discuss this more. Particularly due to the sensitive nature of this evening's topic, we are so grateful that the two thoughtful and compassionate experts who are joining us to share their perspectives are with us this evening. Professor Chaim Seiman is a professor and chair of Jewish law at the Charles Whittaker School of Law at Villanova University and author of Halacha, the Rabbinic Idea of Law with Princeton University Press. He sits as a dayan, a rabbinical court judge with the Beit Din of America, and serves as an expert witness in insurance law and Jewish law in federal court. Dr. Yael Machtinger is an award-winning professor in the Law and Society program at John Jay College of Criminal Justice on the Upper West Side. Her doctoral dissertation and upcoming book is the first comprehensive qualitative interview-based study on get refusal. We're going to begin by hearing a brief introduction from each one of our panelists and then give them some time to address one another. Then I'm going to ask some follow-up questions. We'll save some time at the end for audience questions as well, so be sure to send your questions to me in the Zoom chat throughout the program. With that, we will turn over to Professor Seiman to get us started with an overview of the halacha and history of Agunah and the legacy and the legality, of the prenup.
Thank you. Thank you, Rabbi Levine, the Jewish Center, Ora, and my co-panelist, Dr. Machdinger, who I must say is really a leading voice on this issue, and I'm honored to be here with her. Just as a word of introduction, Ora mentioned that I sit occasionally as a dayan on the Beit Din of America. That's correct. I only sit on commercial cases, not on any divorce or get-related cases. And just to clarify, everything I say here today is my personal opinion and not that of the Beit Din of America. So I think Ora gave a brief but good summary of the basic structure of the divorce law and what Agunah means and how its definition has changed, or the nature of the problem has changed over time. So I think we could jump right into really what we might call the modern Agunah problem, which is really one of the last couple of decades as it's come to be understood, and is sometimes called siruv get or mesurevet get, meaning a woman almost, in the typical case we'll talk about, who wants a divorce, but the husband, either out of spite or to use in leverage to get a more favorable financial or child custody settlement, is unwilling to give a get. The issue is, of course, that while fundamentally halacha allows a husband to unilaterally divorce a wife, meaning just at will, so long as he pays the ksuba, the reverse is not true. In addition, a valid get must be given of the husband's free will. Otherwise, it's what halacha calls a get me'uset, a coerced get, which is usually invalid. We could state this in maybe more modern terms, that it's usually not true that the wife has a right to get a get. The basic halachic regime assumes that a Beit Din, or a Jewish court, will only require the husband to give a get if the breakup of the marriage or the dissolution of the marriage is considered his fault. And these are pretty narrow, difficult to meet categories that typically involve not fulfilling either a halachically mandated duty or a social expectation of the marriage that's incumbent on the husband or wife. Now, the fault plays differently in the case of a woman or a man. When the wife is at fault, she can halachically be divorced, and the husband is relieved of the obligation to pay the ksuba. By contrast, when the husband is at fault, the Beit Din can order a husband to give a get and ensure that the husband meets this demand and grant the wife her ketubah payment. This is the sort of classical halachic framework that informs the issues that we today call Agunah. Now, one issue that's worth thinking about that I'd like to bring to your attention is what I call who is considered an Agunah. And there's a contrasting set of statistics from about 10 years ago that I think puts a nice point on this, both out of Israel, but the basic point is applicable in the United States as well. The administrators of the Israeli rabbinical courts, the Rabbanut courts, in the mid-2000s said that there were about 180 Agunot in Israel. By contrast, right around the same time, a committee in the Knesset focusing on the advancement of the status of women in Israel said there were around 100,000 Agunot in Israel. Now, even accounting for different sort of way, even taking account different ways of counting, the difference between 200 and 100,000 is huge. And I think trying to understand what's behind these numbers will help clarify some of the issues at stake in the Agunah crisis. Let's start with the low number, the 200 number. What does that represent? Well, that represents a number of women whose husbands have been adjudicated by a Beit Din here in the Israeli system to owe a get, but are refusing to grant it. In other words, a Beit Din went in an official proceeding, found the husband at fault under the halachic criteria of fault, and say, you must give a get, and he's not giving a get. And per the Rabbanut, that's what an Agunah is. I would say the American equivalent, our system is a little bit different, it's not tied to the state, but these are likely the cases that one hears about in the newspapers and social media, and that are sort of well-known, well-publicized Agunot. Those are typically cases where a Beit Din has ordered a husband to appear before it and or to give the get, yet the husband refuses. But I think it's equally important to focus on that much larger number of 100,000. What does that represent? I think that represents the number of women who are adversely affected by the asymmetries, the imbalances in halachic divorce laws, and who are forced to make sacrifices in the context of marriage and divorce that are not demanded of men. Sorry, I see a note here. Okay, I will try to speak louder. Apparently, it can't be heard very well. So these 100,000, I think, represent women who are, because of the asymmetries of the halacha, are forced to make sacrifices in the context of marriage and divorce not demanded of men. So what does that mean? Parties in a divorce are typically negotiating the way towards settlement. When everything breaks down and the husband refuses to give a get, that becomes one of the well-known Agunah cases. But what about times when a woman must make concessions in terms of the financial settlement or the child custody in order for there not to be a fuss about the get? And I think that touches on the complexity involved in defining who is an Agunah and the extent of the Agunah issues. Anytime parties are negotiating any dispute, they're going to use whatever leverage they have. In this marriage context, it's going to be family money, future earning potential, social standing in the community, connection with important rabbis, institutions, community personalities, the relationship with the children, the health, the wellness, the age of the parties, and the recourse to secular court. We can think of all these as cards that one side might play or another as they're negotiating are going to influence how the money and custody issues are evolved. And I would say included in this mix is one card that only the husband has and not the wife, and that is, of course, the ability to give a get. But it's not always easy to see how that issue is working independent of these other variables, and much of the argument of who is an Agunah, I think, revolves around this. So to take an example, suppose the wife comes from a wealthy family that can afford high-powered lawyers and is well-connected in the community, and the husband doesn't. Is a husband's attempt to sort of leverage the get to equal the playing field, is that a get refusal or not? A more challenging example, I think, is suppose the wife wants to go to secular court to determine property allocation. The husband says, I want to go to Beit Din, and as soon as the wife signs an agreement to go to Beit Din, he'll give a get. Is that considered Agunah? I don't know. I think these are hard questions. Now that implicates a more basic question about how we understand marriage, and the truth is connected to the theme that Rabbi Levine mentioned, the sort of interaction between what I call Jewish ethics and Western ethics. Colloquially speaking, I think an Agunah is a woman that the community thinks has a right to exit the marriage, but is still technically anchored to the marriage. That, of course, begs the question, under what standards and who decides when a woman has a right, or when any party, but typically here we're talking about women, has a right to exit the marriage? Under what we might call the traditional halachic view, right, marital property belongs to the husband, and the wife's rights are contained into the ketubah. A woman only has a right to exit the marriage if she can show the husband's at fault. From that perspective, common to the Israeli Rabbanut and in the Haredi world, there are going to be relatively few agunot, because there are relatively few cases where a Beit Din will determine that a woman is owed a divorce or has a right to a divorce, and then fewer cases when the husband is not going to comply. If we move to the other end of the spectrum, the one embedded in modern American law, the idea is what's called unilateral no-fault divorce, i.e. either party can get out of the marriage sort of whenever they want with no real penalties and without needing to show fault, what secular calls irreconcilable differences. In addition, the assumptions about marital property are that, at least as a starting point, they each get half the estate, and then that's balanced by various considerations. So part of the question is, which law is going to be our baseline? Which law are we bargaining around? Which law, which system, which set of norms establishes the right to divorce? Traditional halacha, secular American law, or some kind of unarticulated combination of the two? In other words, how do we know whether someone is being rightfully or wrongfully refused to get? In the modern Orthodox community, I don't think that many adhere to the view that of the sort of super traditional view that fault must be proven, but I'm not sure it goes all the way to the sort of frictionless exit. It's probably somewhere in the middle. All right, the last point I just want to talk about is what's become in modern Orthodoxy the sort of the most accepted and common way to blunt some of these issues, and that is the prenup. Now, here we have to understand the interaction between American law and halacha and how they work together in this context. So American law does some things to make this harder and some things to make this easier. First, to make it harder, no Beit Din can assert jurisdiction over anybody that hasn't consented to it. A couple years ago, maybe you guys remember, there was a famous case of Mendel Epstein, who basically created his own Beit Din to resolve Agunah issues and went around imprisoning people and physically coercing people. And when he came and said, hey, I'm a Beit Din performing my Jewish law function, the American court said, no, you're just a guy assaulting people, right? Secondly, no court can force a person to perform a religious act, and giving a get is going to be seen as a religious act. So in that way, the American law makes it difficult for Batei Din to get control over this and make sure and resolve Agunot issues. On the other hand, American law makes it very easy, if the parties have agreed, what's called arbitration, to appear before a Beit Din and to submit in its authority. Not only does American law let that happen, but then it will use its machinery of enforcement to enforce a Beit Din award, certainly of a financial matter, and it will treat it, a Beit Din's financial related decision, as if it were a court decision. Now, the BDA or the RCA prenup really builds on these two ideas and kind of ties them together. What it is, it's a really interesting document that's half an American law contract and half a halachic agreement. On the American law side, what it does is that the parties say, we're going to agree to arbitrate things related to the get in front of the Beit Din of America. That means that the financial parts of the Beit Din's decisions can be enforced in US courts, and secular law courts will not let you go anywhere else and will force you to appear before the BDA and will then work to enforce the BDA's judgment. That's the American law part of it. The halachic side, what the prenup does is it says that al pi halacha, according to halacha, a husband has a chiyuv mezonot, an obligation to support the life and the life and the food needs and the life's necessities towards his wife. In theory, ideally, they live together and it's taken care of. But when the marriage breaks down and the wife has a separate abode from the husband, what the agreement says is that obligation will now be enforced in terms of a $150 a day payment, which comes up to just under $55,000 a year. Now, what the theory is that since, according to the husband who was not given a get, the couple is still married, therefore his Jewish law obligation of mezonot, of living expenses, still applies. Since they're not living together, he has to support them. So what the prenup does is it reinforces this halachic obligation. It says that the Beit Din is the tribunal responsible for doing that, for administering that. And then as an American law instrument, also grants the court jurisdiction to the Beit Din jurisdiction to do that, which will be held up in court. Once the couple separates and the wife demands the get, the sort of prenup meter starts ticking at the rate of $150 a day. The effect is to try to rebalance the power dynamics between the husband and wife. And ideally, it takes away that leverage that the husband may have to withhold the get in order to obtain more favorable settlement terms. Versions of this prenup have been in the use since the late 80s and early 90s. It's been tested in civil courts and generally held up. In one case, the husband in court tried to say, hey, American court, you can't enforce this agreement because it's unconstitutional. You'd be forcing me to do a religious act, and that's against the American Constitution. The court didn't buy that argument, saying, no, we're not enforcing you to give a get. We're merely enforcing the monetary obligation that you contractually obligated yourself towards, and we're just enforcing this contract like courts enforce every contract. Many prominent poskim, including Rav Asher Weiss, Rav Ovadia Yosef, Rav Zalman Nehemiah Goldberg, and here in America, Rav Herschel Schachter and Rabbi Willig, have approved the RCA prenup on account that it merely enforces the pre-existing halachic obligation of spousal support or chiyuv mezonot. Some in the Haredi community have objected on grounds that what this results in a get me'useh, a coerced get that is only being given under the threat of financial penalty, and the Haredi community has generally shied away from using it. A more recent development is that there's been a version of the Haredi prenup that's been published online that works a little bit differently, and maybe in the Q&A we can get into what that is, how that works, and how that's different. So hopefully that will provide us some background to appreciate Dr. Maftinger's fascinating research and insights into this issue.
Thank you so much, Professor Seaman, for that overview. We are now going to hear from Dr. Maftinger, who's going to share with us about her research and findings on get refusal.
Amazing. Thank you so much for having me. Thank you to Professor Seaman. It's always great working together. So I'm just going to jump right in for the sake of time. The way it's going to work in the next 10 or so minutes is that I'm going to share with you first a little bit about my study, and then 4 kind of takeaways, lessons or findings, if you will, from that study, and I'll kind of expand on each one as we go. So I conducted the first and actually the only comprehensive interview-based study of Jewish divorce and comparative study between New York and Toronto, where I'm from. And the largest, these are the 2 cities with the largest and most diverse Jewish centers in their respective countries. Focusing on law and religion and having conducted primary interviews with women refused to get, Misravot get, and other diverse stakeholders, the larger project actually brought together literatures and theoretical debates that had not previously been in conversation, including Jewish law and Jewish feminist debates, in addition to socio-legal scholarship, which has to do with the ways in which law impacts society and vice versa, incorporating the fields of law, culture, religion, secularism, and gender, and with a particular focus on legal pluralism, which studies the overlapping of multiple legal systems within one jurisdiction, like halakha and civil law. In this larger undertaking, I examined get refusal by tracing gaps between law reform and social behavior, exploring the degree to which changes in our secular civil legal systems, both in Toronto and in New York, elicited changes to Jewish legal orders and normative behaviors regarding get refusal. So I also ended up looking at these messy entanglements that are experienced and navigated both by women and by Jewish communities writ large. Ultimately, I demonstrate that get refusal persists despite the existence of the civil remedies that we have in the official legal system, and despite the traditional remedies, the halachic remedies in sort of the unofficial religious system, principally to the detriment of women. And so, although get refusal does disproportionately impact women, I want to stress that the problem of get refusal is actually a Jewish ethical problem affecting us all, being that it's rooted in a basic regard, or disregard rather, for kavod habriot, respect for all those created in God's divine image. So now I'm going to share just 4 of my findings. The first is that get refusal, and actually Professor Seyman mentioned this as well. The first is that get refusal was never a halachic principle. It was actually a learned behavior. And just as we learned it, we need to unlearn it. We need to challenge the notion that a get is negotiable. So the idea that a husband can wait and negotiate all other matters such as custody and access and alimony, etc., that creates a power imbalance and reinforces the idea that a get is a tool of abuse, right? Because he can wait to negotiate all of those things before granting a get. Rather, in terms of civil proceedings, this really opens the door for get extortion, implying that if a woman grants her husband favorable terms on all those matters, he in turn will give her a get. As a community, we've been tolerating rather than remedying this phenomenon for too long, and this is not moral, nor is it halachic. And I would argue it also goes against one of our foundational ethical principles, tzedek tirdof. We need to pursue justice. And if we really do value justice, then we have to challenge this idea, which really has only taken hold in our communities over the last 50 years. The get has to be given prior to and separate from any and all other divorce proceedings and negotiations. And that's perhaps the most practical takeaway advice that you will hear. The second finding, and another critical policy outcome that emerges from my study, is the centrality of domestic abuse in the lives of women refused to get. And really, woman after woman illustrated that get refusal is symptomatic of other abuses endured during a marriage. In fact, in interviews, I would hear the words abuse, control, fear repeated upwards of 50 times in one interview. Abuses would range from emotional and psychological to financial and spiritual, and even to physical and sexual in some cases. So just as communities are hard-pressed to ignore domestic abuse, so too we should not be ignoring get refusal, and it ought to be purposefully and strategically framed and understood as one potential abuse of any number of abuses that individuals may come to endure in unhealthy marriages. Refusal of a get is often the final vestige of control in a pattern of controlling behaviors. And women express that get refusal is often much harder to endure than physical violence, because once you're actually able to remove yourself from an environment of physical abuse, it stops. But the abuse of get refusal is in a sense more difficult because it follows you everywhere. It ties you down, and only one person has the ability to release you. You cannot free yourself. I further argue that remedying the abuse that is get refusal is not going to come about by changing halacha, which some people rather radically suggest, I would argue. And I think this because I don't believe halacha is the problem. And in fact, the majority of divorces, thank God, do not descend into get refusal. So instead, I think the problem is actually with abusive individuals who find support in their families and communities. And the problem of abuse actually cuts across all identity markers. In fact, abuse at the time of marriage breakdown is not unique to Judaism. On the contrary, the problem of power and violence in intimate relationships will be deployed just as it is in all kinds of abusive conjugal relationships, Jewish or not. There unfortunately are bad people out there, and some of them are men who happen to be religious, and these bad individuals will use whatever tools they have at their disposal to bolster them in their abuse, and sometimes that includes religion, and in our case, halakha. The best way to combat this manipulation or subversion of religion, which rationalizes get refusal, is to acknowledge everywhere and always that refusal of a get is abuse. And again, I think in Judaism, this goes to one of our key ethical principles of bechira chofshit, free choice. It is all the more noteworthy, really, that one gender's free will comes at the cost of the other's. If it is a man's choice not to divorce his wife, he is depriving her of the choice to free herself. This brings me to my third finding that I want to share with you. Because anyone can experience domestic abuse, and get refusal is one type of domestic abuse, then by extension, anyone can potentially be a victim of get refusal. And they have. Research has shown that get refusal is actually interdenominational and indiscriminate, cutting across typical identity barriers and affecting all types of women, not just the religious, not just the modern Orthodox, not just the Haredi. Which is a common and actually detrimental misconception. In fact, I interviewed women of diverse ethnic and national origins at various socioeconomic levels, at varied ages, women who were married different lengths of time, women who were married at different ages, women who were refused a get for different lengths of time, women with children and without, women with current varied marital status. So to clarify, the phenomenon of get refusal is not one that targets a very small and distinguishable group of only ultra-Orthodox women or modern Orthodox women. Any Jewish woman might be impacted at any time. I interviewed women who identified as not at all affiliated, as traditional, as observant, as conservative, modern Orthodox, ultra-Orthodox, Hasidic, women who identified as from birth, Baalot Tshuva, women who were Ashkenazi, Sephardi, Bukhari, Lubavitch, women who were very comfortable living on Upper East Side or Upper West Side condos, women who needed food stamps to feed their children, women who were in their 20s, 30s, 40s, 50s, 60s, and even 70s, women who were married in their teens or 20s and later in their 30s or 40s. I interviewed women married only a year or two before being refused a get, and women married 20 or 30 years before being refused a get. I interviewed women who were only agunot for a year and women who were agunot for upwards of 20 years. I interviewed some who were happily remarried, some happily single, and some still in limbo, either refused a get and with a civil divorce or without either. So really there is no unifying or homogeneous factor about the demographics of women who might end up misurvot get. And because of that, we need a grab bag or toolbox or plurality of remedies, right? Because if there's no one woman, then there can be no one solution. Different women will be comfortable with different approaches rather than a one-size-fits-all approach. And so this may not be the most popular thing to say, but while prenups will work for some, they will not work for all. While e-shaming or public shaming or social media shaming might work for some, it won't work for all, and so on and so forth. There is no one effective remedy. And finally, my last, but perhaps my most significant conclusion in light of our topic this evening is that Jewish women are entitled both to their right to religion and their right to divorce or to be free from abuse in divorce. These are at times constructed as conflicting ideals or demands, right? I've heard this saying that people who are religious should accept that they might have trouble getting divorced, or people who want to easily divorce shouldn't be religious, or they should be okay with walking away from their religion if they're faced with divorce refusal. And in fact, again, the right to be religious and the right to be free from abuse and divorce are not contradictory. And I would argue that they are vital ethical principles compatible both with our secular and our religious worlds. In fact, as you all know, the United States has constitutional protections for freedom of religion with the First Amendment, and CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women, which was adopted back in 1979, addresses inequalities within marriage and family life in Article 16, and it explicitly discusses the equality men and women should face upon entering and during marriage, but also upon its dissolution. And this is important to note because it makes it explicitly clear that the persistence of get refusal is not only ethically wrong in terms of our own halakha, but allowing get refusal to persist is also in contravention of international principles of justice and equality. This is undoubtedly unethical. And the fact that there are Mesurah get in every major Jewish community around the world is also unethical. Moreover, stressing that women have a right to practice their religion and to exit their marriages also speaks to feminism's most fundamental principle, which in theory is the right to respect diverse choices of diverse women, and sends the message to the non-religious world that choosing religion does not have to mean giving up human rights or inevitably becoming chained to an unwanted marriage. So in conclusion, 4 takeaways. Right? We must challenge the notion that a get is negotiable. This was never a halachic principle. It was learned, and we need to unlearn it. The second one is that domestic abuse is central in the lives of Mesurah get, and we need to understand that that's very problematic. Because anyone can experience get refusal, we need a variety of different remedies. And finally, that women have the right both to their religious choice and to enter and exit their marriages. Women's relationship to faith and their relationship to law is complex and multifaceted. Each plays a role in seeking a particular solution to get refusal over another for each individual woman. There is no one relationship, and so too, there is no one solution. And I'm looking forward to hearing your thoughts, questions, and thank you for having me.
Thank you so much, Dr. Machtinger. So I think for the sake of time, I'm going to direct questions, and if you have things that the other person mentioned that you would like to address, try to fold that into our to some of these questions. So Dr. Machtinger, you mentioned explicitly a few ethical principles such as tzedek tirdof and the idea of enabling bechira, free choice. So I'm wondering, since this is a lecture that is targeted specifically at questions of ethics, if Professor Samen, if you could try to identify some specific ethical principles or concepts or tensions that you see at play here.
Sure. And thank you for that. That was enlightening. So I would say, and it's really just elaborating on something that Dr. Machtinger said. Look, as I mentioned, there are different formal legal baselines between, I would say, contemporary secular assumptions of marriage and divorce and classically halachic ones. However, there is no halacha that says that one must demand all of those and make it as difficult as possible. In other words, it is clear that halachically the parties can enter into a consensual agreement to divide assets and custody and whatnot. Sorry, I just have to speak louder. So in other words, there is nothing in halacha that prevents, and maybe even things that push towards a settlement as per the parties' agreement, whether it meets the formal definitions laid out in Shulchan Aruch or in American law. The ethical point I think that Dr. Machtinger mentioned was that what we assume coming in are learned behaviors, and that if the community comes together and says, these are the expectations and assumptions that we're going to do this on, in which case the get and the threat of get refusal does not become a bargaining tool. So then that is a behavior I think we need to all collectively hold our hands and do. And I want to just reiterate what she said, that there's nothing in halacha that pushes the other way. So that would seem to me one issue. The other one is, though, if we speak of like where the tension is that I believe there are somewhat different understandings of marriage at work here. And I think that some of the reason why the Agunah issue, as we're constructing it here, is relatively new, is because it's a function of the fact that Jews now have recourse to the secular courts and to the norms that those courts are promoting, right? In a world where there's no recourse to that, the Agunah issues look differently, right? That part of what we have here is, and I don't want to state it merely as recourse to the courts, although that's the way it would show up in the most doctrinal sense, but absorbing those norms, right? I think as modern Orthodox Jews, we live in between the norms of the fault-based system articulated in Halakha and the more egalitarian system that shows up in the secular divorce. Divorce, and I think, and really what Dr. Machninger said, like we're living those tensions, and to some degree, some of what we see is a product of those tensions, and then of parties, instrumentally and in bad faith, using the arbitrage between those systems to their advantage.
Before I ask the next question, Dr. Machninger, do you want to respond or add something?
I think that was great. I think we can go to the next question.
So as a modern Orthodox synagogue, the Jewish Center wants to be really conscious and aware of the way in which these issues are particularly impacting our community. So you mentioned, Dr. Machtinger, how this cuts across many communities and many demographics. And Professor Seaman, you talked specifically about the Haredi prenup, but we're curious to hear a little bit about what this looks like right now in our community.
I guess I can start with that bit. So a number of things are happening. When we were preparing for this, I think where you asked me, is this no longer going to be a modern Orthodox problem because the prenup is slowly going to sort of eradicate it? And I encourage all of you to think beyond New York, beyond North America, beyond the Beit Din of America's purview, because there are modern Orthodox communities around the world. Toronto is one of them, where the prenup is not being used for a number of reasons, right? One of the reasons is the hashkafic ideology of the local Beit Din in Toronto, but also legal reasons. There is no religious arbitration permitted in Ontario, so the prenup that's currently in use is not legally valid either. So the problem will persist in modern Orthodox communities around the globe that don't have the ability to use the prenup. So that's one part of it. The other part of it is, and I don't know how many people are familiar with what's been happening on social media in recent weeks and months, but there's been a big shift and really a trend going on in our communities that's happening on social media, trying to pressure husbands into giving their wives a get. So that's what's happening on the ground today. And there's pros and cons to that. One of the pros is that it's always good to bring attention to it. And in fact, a couple of gets have been achieved from what I call e-shaming. But actually, I think we need to think a little bit critically about putting our social justice in the hands of Insta shamers, I call them, right? The women on Instagram and men too on Instagram, because it is a trend, right? And so they are only going to follow the trend until there's a new trend. And we need to keep putting pressure on this issue and not let it be something that Instagram people are going to share and and in between sell lipstick and so on and so forth. This needs to be something that we all care about, regardless of the trends on Instagram. And more than that we've actually been using public shaming for hundreds of years, right? This is not a new found creative way of exacting gets. This is actually part of a tradition going back hundreds of years. When I spent time doing archival research in the New York Public Library, you can actually find editions of the Jewish Daily Forward in Yiddish, and you can see a gallery of verschwundene Männer, a gallery of vanished husbands. And it's literally a wanted ad of men who would have absconded in the traditional sense of what an Agunah used to be, where men would disappear and leave their wives without a get. And you see wanted ads very similar to the sort of posters that you see today from ORA, the Organization for the Resolution of Agunah, and all over Instagram, trying to shame men into doing the right thing, essentially. So this is not like a new and revolutionary tactic. This is a part and parcel of our tradition, and really goes to Rabbeinu Tam's cherem, which we should all do, by the way. I don't think we do that enough in real life, that we shouldn't resort only to doing that on Instagram. So those are just, a few tidbits about what's going on today in our communities and beyond. Professor Steinman, take it away.
Sure. So I want to make 2 points. One about modern Orthodox and the prenup, and one about my sense of this Haredi prenup. So as was mentioned, the RCA's prenup is meant for American communities. And I say America, La Fouque, Canada, and La Fouque, Israel. In other words, to exclude, so it doesn't work in either of those places because the legal system is different, right? Canada is very skeptical of religious arbitration and therefore doesn't work for that way. In Israel, these things are centralized under state courts and it doesn't work for that reason. So it's designed for a American United States system. I think there it works pretty well, but it has its limitations. Like any contract, I teach, my day job is teaching contracts. So if the contract can't be found, that's going to be a problem. If someone is judgment proof, basically too poor that they're never going to be able to pay the money, so then this person has lots of debts, and this is another one, but it's hard to see how that works. We can go the other side of the income scale. If the person is very rich and $50,000 or 50 is not much. Fortunately, I am not aware of cases where this has actually happened, but that is the potential. So, it's a contract and it works like all contracts do, and it has the limitations that all contracts have. For a moment, in terms of a new development in the Haredi world, so as I mentioned, the Haredi world is somewhat skeptical or of the RCA prenup because they fear it might be considered a get me'useh, a forced get. Now, what they have done, and this is a coalition called, I believe, Yashar, that has published a draft prenup for use in the Haredi world, signed off by Haredi Rabbanim. And it's interesting because you see how they conceptualize the case differently, and this will tie into the shaming that Dr. Machninger mentioned. So if the RCA prenup is written against the backdrop of the secular expectations of divorce law, that basically thinks that a woman who wants out of a marriage should be able to get to do that, the Haredi world sees the problem differently, that husbands are refusing to submit to a beit din to determine whether the husband has acted in a way requiring him to give a get. Because American law can't force anyone before any beit din, and because, particularly in the Haredi world, there is no central beit din, but there's many, many rabbis and many, many beit dins. It's very, what tends to happen in that world is that someone gets a summons or a hazmana to a certain beit din and immediately goes to a different beit din or to an ad hoc beit din, call it a zabla, to basically counter that. And each party gets rabbis and important Rosh Yeshiva to their sides, and it becomes a sort of stalemate all the while the get issue is not being resolved. So the Haredi prenup attempts to fix this problem by using American contract law to say up front, the parties agree that this beit din will have jurisdiction over the get and all financial issues related to that. And like with the RCA prenup, the secular court will enforce that. The main difference between the two is that there's no triggering mechanism in the Haredi prenup, unlike the RCA one, which says when the couple separates and the get is demanded, that's when the stipulation for the mezonot begins to play. The Haredi one is silent about this, about what standards the court should use to determine whether the woman is owed a get or not. That's deliberate because in the conception of this, each court should, or each couple should choose a court that will reflect what they think the halacha should be and how it should apply to them. So therefore, you can imagine under that prenup some Batei Din working very, very differently than the RCA, and some working much more similarly. But the point is that's not contractually in there. It's merely a way of channeling the dispute to a particular Beis Din and avoiding what the Haredi world sees as the major problem right now, which is sort of fights over which Beis Din will have jurisdiction.
Thank you. The next question I want to ask has been touched on also by both of your remarks, and it's really a question of power and who has power and control in this conversation. So clearly, a husband has a certain kind of power in this conversation, and we talked also about social pressure and communal shaming, and that also is a kind of power. I'm curious if either of you can speak to identify some other player where power lays and who should, in the ideal situation, have control in these kinds of circumstances.
Should I start? Okay, so, it's a hard question. Ideally, power is more equally dispersed. Certainly, I think that families of recalcitrant spouses have a tremendous amount of power, and sometimes they realize it and sometimes they don't. There's actually a very famous case. I'm going to say the name. I don't know. It's Mayor Kin is a very well-known case out in Los Angeles, and he has gotten a heter rabbanim and he has remarried. And a few years ago, I was with my mother in a light shop in Toronto. We were renovating our kitchen and she was looking for sconces, and we were prepared to order the lights. And I noticed the business card was with the last name Kin. And I said, "Oh my gosh, are you related?" And it was clear that there was a connection. It's not a very common last name. And needless to say, we did not purchase our lights there. But this goes to the point that families wield a lot of power. And most of that time, that power is used to support the recalcitrant spouse. And communities, sometimes they recognize that and sometimes they don't. But we should be recognizing that families are often supporting, whether it's intentional or not. And we cannot tolerate that support to happen. And not only do we have families who are supporting, but sometimes there are communities at large, synagogues, communal rabbis, thankfully not at the Jewish Center, who do support husbands in their recalcitrance. And again, we cannot tolerate that. I really think that it's a grassroots movement has to happen from the bottom up. Like I said, we have to kind of unlearn these bad habits that can be negotiable, and we have to relearn the correct way of doing things. So this can happen in schools from very young ages. This can happen with kala teachers and chassan teachers. This can happen in universities. This can happen all over the place. So the power needs to kind of be diffused from the people who have the most power, which are usually husbands who are refusing to release their wives, and we kind of need to take some of it back, I think. Professor.
So I want to largely agree with that and just add a mashal. As was mentioned before, historically, right, Jews did not enforce their own rules through formal systems of jail and punishment, right? These were nidui and cherem and shamta, various forms of what today we would call social sanctioning. So that really is the traditional Jewish way. Occasionally you'll have someone who is willing to live on an island and sort of wither everything, but everyone needs to live in some sort of, that does happen. But I think most people, even most Masarvei get, need to live in some sort of sense of community that they belong, and exactly as was mentioned, they're supported by family, communities, networks, etc. Just as a mashal, it's not perfect as an analogy, but if we go back 100 years, kashrut standards in America were very, very diverse and very, very hard to navigate, and each person basically did what they wanted. And then, really in the post-war period, and right, what we've done is consolidated to national standards, right, of kashrut, OU, star K, et cetera, Chav K, and they all sort of work with each other and respect each other. So I thought about this as a sort of model, right, that now there's certain things that you used to be able to do that you can't do, and the other way around, right? And that even though there's no kind of formal state or coordinating mechanism, as a community, we've come to say, even though people have different hashkafas and different standards of kashrus, right? These are the standards that the sort of North American Orthodox community is going to live by, and they stick. Centralization sometimes has its own problems, but I wonder, thinking today of like, just to the point here, this can happen. In fact, this has happened in, I don't want to say it's the same, but it's something that's, has certain parallels to what we're talking about. It's really a cultural shift and a commitment to say, these are standards that we're going to hold ourselves to.
I think that's so fascinating to hear your answers together, because I think in a way, Dr. Maftinger was talking about dispersing power in a sense. And I think you're speaking about recognizing, consolidating, and sharing a kind of sense of standard, which I think is a really, really interesting contrast. One question we have from somebody from the audience is curiosity about the source behind, if there is one, behind why so many rabbis state that a get does not need to be given before a civil divorce is filed.
Chaim, is there a source for that?
I just want to think here. Why a get does not need to be given before, because here's my best guess, right? My best guess is that this has to do a little bit with which standards will be used to divide, property and custody. In other words, part of what happens is we can think of the get in a very narrow way or in a broad way. In the narrowest way, it's a ritual, all right? It's a ritual requirement that is wholly separate from the resolution of the financial and custody issues of the marriage. But we could also think of it as more expansive, as part of the suite of things that happens in a divorce, in which the get is sort of representative of those other things. My intuition as to where that's coming from is to say, look, Jews should resolve their marriages under Jewish law in a Beit Din. It's true that as a matter of American law, you also have to do it in court, but that doesn't, that there's no rule that says it has to be adjudicated there. The parties can come up with a consent document and the court will sign off on it. My best sense of where that's coming from, and it's related to something called the Isur Arkaot, the prohibition against Jews litigating with each other, including husbands and wives in secular court, is that this is a way to channel not just the get in the ritual sense, but the thicker set of norms that halacha brings to marriage and divorce law, to channel it that way rather than to secular court. That would be my, we'll call it, educated guess.
I have a more cynical approach as someone who does not sit as a dayan on the Beit Din, like Professor Saman. Frankly, I think that it has to do with power of the Beit Din, right? I actually think that the Beit Din, not so much maybe the Beit Din of America, but certainly the Beit Din in Toronto and in many other contexts outside of the Beit Din of America, Batei Din, their power is a little bit at risk, right? They're trying to hold on to their power and their influence in society and in communities. And I think that if there exists this notion that you have to deal with all marital issues in the Beit Din, then that reinforces the need for a Beit Din and their power in communities. And so what ends up happening is that they encourage people to really deal with all the issues in Beit Din, and the get they leave at the end, right, for the last step. But really, what's in the best interest of women certainly is to deal with the get first. And then, divorces are never fun. I mean, am single myself, but I've now become a divorce expert, and divorces are never something that is a fun activity, and it's very painful to go through, and people can hash it out and negotiate, to their heart's content, but that should all be done separate from and after a get is given and received. And so that really, I think, needs to become the norm.
Thank you. So we have a few very technical legal questions, which I will not ask here publicly, but if you are one of the people who has sent a very technical legal question and you would like to be connected with one of our panelists, please feel free to email me and we'll figure something out. Before we close, I wanted to end by asking each of you to share a specific piece of advice about an action item. As Rabbi Levine mentioned, we want to make sure that we remember that this is a current issue. What can be one action item that everyone here listening can walk away with in order to alleviate some of the pain of this issue in our community at large?
I think yeah, I don't know. Professor Simon wants to go ahead. I think, so like we've already talked about a number of things. First of all, events like this with a supportive rabbi like this, it's the first step, and you should not take this lightly. This is not something to be taken for granted. This does not happen in a lot of communities, and it's very important, right? That you're just talking about it openly, that you can talk about it with your rabbi, and you should go forth and talk about it more, right? I used to say that I'm changing people's minds about get refusal one Shabbos table at a time. So talk about it more, talk about it with people, talk about it with your children, and keep talking about it. But also, if you know of a woman who is or recently was refused a get, be nice to her, right? Be inclusive of her, take care of her in your communities. Of course, you should all sign prenups, even if they may not always work. And you should keep spreading the word, right? That we're not going to tolerate the abuse that is divorce refusal. Professor Simon.
Sure. I think this is more in Dr. Maffinger's expertise than mine, but when we talk about these abstract things like social consensus, right, that is formed by individuals making decisions, a lot of them speaking up. I'm not going to say, look, normally I say if a wedding is not kosher, we wouldn't go to it, right? So if the wedding is happening without a prenup, now, don't make that a blanket rule, right? Sometimes there's a cousin, right? There's always stuff, but in other words, right? Weddings are interesting things because they're both public and they sort of both cement and depend on communal support. And like I said, and prenups help. They don't maybe always help, but they often help. So the RCA has a standard that its rabbis have to administer a prenup. But I would say, right, imagine if no one went to a wedding when there wasn't a prenup, well, then that would change. Now, we all can't control everything, and I'm not saying that if your brothers get it, let's not be silly about this, but we can move the needle a little bit, and that to me is something we can do. It's very easy, I think, and we talked about this before. In the modern Orthodox community, and I think Yael's presentation is very good at disabusing us of this notion. It's very easy to say, oh, we've got to figure it out, it's their problem. And in some ways that's true, and in some ways that's not. And hopefully we've understood a little bit the ways it's not, and where our actions can work here.
Thank you both so much. This discussion was so nuanced and enlightening, and I think empowering. Thank you so much for joining us, and thank you for everyone who joined us this evening. And a reminder to, if you have not yet sign up for the Jewish Center dinner next week. We hope to see everybody there. Thank you, Dr. Machtinger and Professor Saman, for your time. Have a great evening.
Thank you. It's been great being here.